The courtroom smelled like damp wool and old paper, the kind of air that had absorbed too many apologies and not enough listening. Every bench was filled, knees pressed to knees, coats folded over laps, faces angled toward the front as if the room were a screen. A ceiling fan rattled without helping. Somewhere near the back, a baby fussed once and was shushed into silence. The bailiff's shoes clicked a steady warning along the aisle, and the court reporter's fingers never stopped moving. At the defendant's table, an older black man sat alone, hands folded as if in prayer. Not because he was pleading, because he was choosing. His blazer was worn at the elbows, the fabric thinned to a soft shine that came only from years of careful pressing. Someone had ironed it recently. You could see the crispness in the lapels, the stubborn dignity of a garment refusing to surrender. His shoes were scuffed at the toes, the leather dull where it had met too many sidewalks, but his posture was straight enough to make the chair look crooked. Across the aisle, a defense attorney, tailored suit, polished watch, hair cut into sharp decisions, rose with a smoothness that suggested he practiced in mirrors. He turned first toward the judge, chin slightly lifted, voice pitched to command the room without raising it. His cufflinks caught the fluorescent light when he gestured, throwing quick flashes that seemed designed to distract. He spoke like the case was a formality, an inconvenience between him and lunch. "Your Honor," he said, drawing out the words as if they were owed interest. "This matter is straightforward. The statute is crystal clear. The defendant failed to comply with the posted policy in a public building. We are not here for stories or feelings. We are here for the rule." He pivoted, letting his eyes slide to the older man, and smiled in a way that didn't reach his cheeks. It wasn't a smile meant to welcome. It was a blade dressed up as courtesy. "Sir," he said, and the single syllable carried the weight of condescension. "I know this can be confusing. Legal language isn't always accessible." A few people in the gallery chuckled, small, complicit laughs that landed like stones. Not everyone laughed. A woman with a stroller tightened her grip. A man in a work jacket stared at his hands. But enough laughter fluttered through the room to give the attorney what he wanted, the sense that the crowd had joined his side. The charge itself sounded minor when the clerk read it. "Non-compliance with public building policy," she said, in a voice that had already repeated it 10 times that morning. But the way the room leaned in, the way the attorney spoke, the way the bailiff kept drifting closer to the defendant's table, made it feel like something bigger, not a policy dispute, but a character trial. The older man's silence turned into a story the room wrote without him, and the ink was suspicion. The judge, already behind schedule, glanced at a thick docket and sighed like he'd been handed someone else's mess. "Counsel," he said, "let's keep it moving. We have a full calendar." "Of course, Your Honor," the attorney replied, as if the judge had just confirmed the attorney's superiority. Then, with theatrical patience, he lifted a printed copy of the statute. "For the record, I'll read it aloud." Slowly. He did, emphasizing each clause like a schoolteacher speaking to a child who refused to learn. He repeated the words "shall" and "required," as if they were magic spells that erased context. The older man's thumb traced the edge of a battered leather folder on the table. It was not new. The corners were rounded, the surface creased, the clasp worn down from years of opening and closing. It looked like it had been carried through rain, through heat, through long meetings and longer waits. It did not look like a prop. It looked like a life. The attorney noticed the folder and smirked. "And I see the defendant has brought materials," he said, pausing to let the room share his amusement. "I'm sure they are very meaningful to him. But meaning is not relevance." Another chuckle, this time closer to the front. Someone whispered, "He's got homework." The whisper sparked a ripple of snickers that didn't reach the judge's bench but reached the defendant's ears. The older man didn't flinch. His hands stayed folded. His breathing stayed even. In the gallery, a phone lifted. Its camera lens glinted like an extra eye. The person holding it angled it carefully, framing the older man at the table. The screen's bright rectangle hovered above the heads like a tiny stage light. Public opinion began forming in real time, shaped by angle and assumption. The attorney leaned into the performance. "Your Honor, this court should make an example here." These policies exist for a reason. If we start allowing misunderstandings, he lingered on the word, letting it drip, then we invite chaos. We invite disrespect. We invite the notion that rules are optional. The bailiff's hand rested near his belt, not threatening, but ready. His body positioned itself closer to the older man, as if the defendant might suddenly erupt. It was a silent message to everyone watching. This man is the risk. The judge tapped his pen. So, he said, addressing the older man for the first time, do you understand the charge? The older man lifted his eyes. They were steady, not pleading, not hostile, just awake. I understand the words, he said softly. I'm disputing the use. The attorney pounced as if he'd been waiting for sound to strike. There it is, he said, a triumphant tilt to his voice. That attitude, that refusal. He's here to argue because he thinks is above the policy. The older man didn't rise to it. He shifted only enough to square himself toward the judge. Your Honor, he said, still quiet. May I submit one document into the record? The attorney's smirk returned, wider. A delay tactic, he said smoothly. Classic. The judge hesitated, eyes flicking to the docket again as if it were a chain tugging him forward. The phone in the gallery zoomed in. You could see the tiny movement of fingers pinching the screen. The courtroom expected a stumble. It expected fumbling and confusion. But something in the older man's stillness, his careful hands on that worn folder, his calm gaze, carried the promise of a different ending. Briefly, the judge said at last, very briefly. The attorney's confidence sharpened. Your Honor, with respect, we can't let every defendant with a folder hijack the calendar. The statute is. Counsel, the judge interrupted, irritation edging his tone. I said briefly, let him speak. The attorney spread his hands in a practiced display of generosity. By all means, he said, as if granting permission rather than obeying the judge. The older man's fingers moved to the clasp of the folder. Not hurried, not trembling, as if he'd opened it 1,000 times and knew exactly what he'd find. The leather creaked softly, a sound swallowed by the room. Before we do this, the attorney said quickly, sensing the room's attention pivoting away from him. I want to be clear. We are not here to debate philosophy. We are here to enforce compliance. The defendant's request is irrelevant paperwork dressed up as. Enough, the judge said, though he didn't sound fully in control. He sounded tired. So, he said to the older man, you have a few minutes. Explain why any document matters. If you can't, we proceed. A clock on the wall ticked loud enough to become a character in the room. Every second felt like a push. The judge glanced at it, then at the docket. The message was plain. The court had patience for procedure, not for people. The attorney used that impatience like a weapon. Your Honor, this is exactly what happens when individuals refuse personal responsibility, he said, turning to face the gallery as much as the bench. They come in here asking for special treatment. They want the rules bent because they believe their circumstances make them exempt. Not special, the older man said, still seated. Just correct. The attorney laughed under his breath. Correct, he repeated, savoring the word like it was naive. So, do you understand what shall means? It means you must, not you might, not if you feel like it. Must. The judge didn't correct the tone. He simply said, let's keep it professional, a weak slap on the wrist that somehow signaled permission to continue. The attorney's questions came like darts meant to stick. Do you know what subsection B requires? Do you know what constitutes a violation? Do you know what the posted policy said, word for word? Or are we just improvising today? Each question wasn't for clarity, it was for dominance. The older man opened his mouth once and the attorney cut him off with an objection, objecting to an answer that hadn't been fully spoken. The judge, eager to move, allowed the interruption. The older man tried again. The judge stopped him mid-sentence. So, the judge said, I need you to stay within what's relevant. Relevant. The word floated in the air like a gate. The attorney stood on one side of it, holding the key. The older man sat on the other, asked to prove his humanity in footnotes. In the back row, a younger public defender watched, her face tightening as if she was swallowing something sour. She held a file to her chest but didn't stand. A court clerk whispered to the judge. The judge nodded without looking up. The court reporter kept typing, expression blank, as if neutrality required emptiness. The attorney went lower. Your Honor, he said, feigning concern, we should also consider the defendant's age. Confusion happens. Memory slips. We can't allow that to become an excuse. A few heads nodded, as if this were kindness rather than insult. The older man's jaw tightened, just once. His breath slowed. His hands remained folded, a deliberate restraint, a way of keeping them from shaking, not from fear, but from the effort of staying composed while being publicly reduced. In the gallery, the woman with the phone hesitated. Her smile faded. She lowered the phone an inch, then raised it again, uncertain what she was filming now. It no longer felt like entertainment. It felt like harm. The judge glanced at the clock again. Sir, he said to the older man, you're running out of time. Make your point. The attorney leaned back, satisfied. He'd engineered an outcome by controlling the tempo. Momentum was a verdict waiting to happen. The older man nodded once, as if acknowledging the countdown rather than submitting to it. May I read one sentence from the legislative history? He asked. The attorney's laughter slipped out before he could catch it. Legislative history, he said, as if the words were a joke told badly. Your Honor, come on. This is municipal court. Legislative history is for real cases. The judge almost denied it. His mouth opened, impatience ready. Then his eyes dropped to the older man's folder. Not the leather itself, but what was inside. Tab dividers, neatly labeled, worn but meticulously organized. Official looking. Not the frantic papers of someone improvising, but the careful filing of someone who had prepared. The detail shifted the room's energy. Confusion flickered into curiosity. You have 60 seconds, the judge said, voice sharper now. One sentence. The attorney smiled like the story had reached its final page. The older man turned a single sheet, then another, his fingers sure. He found the place he wanted and did not waste a breath. This statute, he said, voice calm but carrying, was adopted with an intent statement. He looked at the judge. With the court's permission, I'd like the clerk to display the portion of the statute that counsel has been reading, and the intent note attached to its adoption. The attorney snapped upright. Objection. Intent statements are non-binding commentary. The judge held up a hand. Clerk, he said, and something had changed in his tone. Less hurry, more caution. Put it up. The clerk blinked, then typed. A monitor near the front lit with text. Black letters on a white field, sterile and final. The attorney's own weapon, now visible to everyone. The older man pointed, not with accusation, but with precision. That line, he said, has been read aloud twice. But the intent note clarifies how it is to be applied. He read one sentence, clean, measured, about protecting public access and ensuring due process, about balancing order with the right of citizens to be treated with respect in public facilities. The room cooled, not literally, but as if someone had opened a window in everyone's assumptions. The attorney's smile faltered, just for a fraction. It returned, but thinner. Non-binding, he repeated quickly. Not law, not enforceable. The older man nodded. Agreed, he said. Intent guides interpretation. It does not replace it. He reached into the folder and slid forward a second document. Not dramatized, not slammed down, simply placed, like a piece of truth laid on a table. This, he said, is a committee record from the adoption hearing. The judge leaned forward. The clerk paused mid-typing. The attorney's eyes darted to the paper, then away, as if refusing to give it weight. The judge took the document, scanned the top, then the bottom. A seal, a docket number, signatures. His posture shifted, small, but visible to everyone watching, including the phone in the gallery that zoomed tighter. The clerk's eyebrows lifted. She leaned to see, then swallowed. The court reporter's fingers slowed for the first time. The older man kept his voice even. My name is here, he said. The attorney laughed once. Too loud, too quick, a sound that tried to break the tension but only proved it existed. Lots of names are on lots of papers, he said, and his confidence sounded suddenly performed rather than natural. That doesn't make it relevant. It makes it specific, the older man replied. I served as a subject matter advisor in the drafting process, brought in to prevent misuse. My role was not political. It was technical. He looked at the judge, not the attorney. I helped write the language counsel is quoting. A whisper sparked in the gallery. He wrote it. It traveled mouth to mouth like electricity. People who had laughed earlier stopped breathing for a beat, as if their bodies had to catch up to their shame. A man in the front row stayed at the floor. The woman with the phone lowered it fully now, eyes wide, cheeks coloring. The bailiff, still near the defendant's table, took a step back. Proximity suddenly looked like intimidation, and he felt the shift before anyone told him. The judge's eyes narrowed at the attorney. Counsel, he said carefully, are you aware of the limiting guidance attached to this statute's adoption? The attorney flipped pages, cufflinks flashing wildly now, less like jewelry and more like distress signals. Your Honor, intent notes are. Counsel, the judge cut in. Why did your argument omit the language on procedural escalation? He tapped the document. Why is subsection language absent from your presentation? The attorney's throat bubbed. Because it's not applicable to. Is it not? The judge said, or was it inconvenient? Silence cracked open across the courtroom. The attorney's performance had depended on everyone accepting his certainty as expertise. Now the certainty looked like concealment. He tried to recover by attacking the older man. Your Honor, with all due respect, this defendant is exaggerating. People say all kinds of things. His verification, the older man said calmly, cutting through the attempt without raising his voice. The committee record has an archive reference number. The minutes are public. There's an email from State Counsel acknowledging my contribution. I can provide it. He did not threaten. He proved. The judge held up a hand to the attorney. Stop, he said, and the word landed like a gavel without the sound. We are not proceeding on incomplete representations. The attorney opened his mouth, then closed it. He looked, for the first time, like a man realizing the room was no longer his. His suit was still perfect, his watch still shining, but the illusion had cracked. Every smug gesture he'd made now replayed as insecurity. The older man spoke again, not triumphant, just steady. This law, he said, was meant to protect order without stripping dignity. It was designed to ensure that when policy is enforced, it is enforced with de-escalation and respect. The purpose was balance, safety and access, structure and humanity. He paused, letting the words settle. If a statute written to prevent abuse is being used as abuse, what does that say about our commitment to the law's purpose? No one laughed. Even the judge didn't rush to answer, because the question wasn't only legal. It was moral, and it sat on everyone's shoulders. The judge glanced at the clock. I want the full legislative record pulled, he said. Now. He looked at the attorney again. We will take a short recess. The attorney protested, but the protest sounded small. Your Honor, this is, the judge interrupted, exactly why accuracy matters. He rose slightly, signaling the room. Recess. People stewed as if released from a held breath. The bailiff moved toward the door. The gallery buzzed with murmurs that were different now, less eager, more uneasy. The older man remained seated, hands folded again, not in victory, but in the same discipline he'd carried into the room. Justice, he seemed to say without words, didn't need volume. It needed precision. When the court returned, the room felt changed, as if the air itself had learned something. The judge's expression was tighter, more careful. The clerk's voice shook slightly when she called the case back. The attorney sat with his papers spread like a barricade, but his shoulders were rigid, his mouth drawn. He no longer looked like a man performing. He looked like a man trying not to unravel. The judge cleared his throat. The legislative record has been reviewed, he said. The court finds that the statute in question includes limiting guidance and procedural requirements that were not represented accurately during argument. He looked directly at the attorney. This court will not allow procedure to become public humiliation. A few people in the gallery shifted, embarrassed by the memory of their laughter. The woman who had filmed stared at her phone like it was heavy. The judge turned his attention to the older man. "Sir," he said, and the tone held something it hadn't earlier: respect. "The case against you is dismissed pending administrative review of the enforcement incident and the building's escalation protocol. Not as a favor, as a correction. The legal basis does not stand as presented." The older man nodded once. Relief moved through him subtly, like a muscle unclenching. He did not celebrate. He did not gloat. He simply received the decision as something that should have been obvious from the start. Then the judge returned to the attorney. "Counsel," he said, "your conduct and your representation of the statute will be noted in the transcript. The court is referring this matter to the appropriate disciplinary channel for review of professionalism and accuracy obligations." He paused, letting the words carry their weight. "You are ordered to submit a corrected brief explaining the omissions. Additionally, the court requests that courthouse administration review the initial incident, including security footage, staff reports, and signage." The attorney's face tightened. He nodded stiffly, as if nodding could contain the consequence. He was not dragged out. There were no dramatic outbursts, no cinematic downfall, just the quiet, institutional gravity of being held accountable in public. A supervisor in a gray suit approached the clerk's station, murmured instructions. The machinery of review began to tighten. Interviews with the building staff, a request for footage, a re-examination of policy wording. It wasn't instant salvation. It was process, slow, imperfect, but real. After the judge moved on to the next case, the room emptied in clusters. Some people avoided looking at the older man as they passed, as if eye contact would force them to confront what they participated in. Others glanced at him with new respect, as if his calm had rewritten their assumptions. Near the hallway outside the courtroom, the younger public defender who had watched in silence approached him. She looked like someone who had been carrying regret since the first chuckle. "Sir," she said quietly, "I'm sorry I didn't speak up sooner." He studied her face, not with judgment, but with the careful attention of someone who knew shame could either rot or transform. "Thank you for saying that," he replied. "I froze," she admitted. "I told myself it wasn't my case. I told myself the judge would handle it. But I knew it was wrong." He nodded, gentle. "The system teaches people to confuse staying seated with staying safe," he said. "But safety bought with silence is expensive. It charges interest." Her eyes glistened. "If you want," she said, "I can help you file a formal complaint about the incident. Or at least make sure the policy is clarified, so this doesn't happen again." He didn't rush to accept. "Not for me alone," he said. "For everyone who doesn't carry a folder like mine." The woman who had filmed hovered nearby, phone in her hand, face pale. She began, then stopped. "I thought I was recording. I don't know what I thought." She swallowed. People online love a clip. They love a punchline. He looked at her, and there was no cruelty in his gaze. "A camera can be a weapon," he said softly, "or it can be a light. Depends on where you point it." She nodded quickly. "I deleted the first one," she said, voice shaking. "I'm going to post what actually happened. The part where everyone assumed. The part where," she exhaled, ashamed. "The part where I was wrong." Outside, sunlight spilled across the courthouse steps, bright and indifferent. The older man paused at the top, breathing air that didn't smell like judgment. He held the worn leather folder at his side. It felt heavier than paper, lighter than it had earlier, as if some of its burden had finally been shared. Over the next weeks, the consequences arrived in the unglamorous ways accountability often does. A formal notice went out about staff retraining. New signage drafts circulated with clearer language, emphasizing de-escalation, consent, and respectful communication. An updated protocol required staff to attempt explanation and assistance before calling security, with specific steps documented. A supervisor reviewed footage from the building incident, interviewed the clerk who had spoken over him, and the guard who had been called too quickly. The investigation wasn't framed as a witch hunt. It was framed as a correction: what should have happened, what didn't, and how to prevent repetition. The judge's transcript note went where such notes go, into the channels that protect the integrity of the profession, slow and procedural. The attorney was ordered to submit explanations and corrections, and his client relationship came under scrutiny. He left that day not in chains, but in consequence, credibility shaken, reputation bruised, forced to confront how easily power could become cruelty when it was applauded. The older man was invited, formally, to consult on the policy clarification. The letter was polite, careful, almost embarrassed. He read it at his kitchen table, the same table where he paid bills and helped grandchildren with homework. A cup of tea cooled beside his hand. He agreed to meet, but only with one condition. This must apply to everyone, he told them. Not because I have a name on a committee record. Not because I can quote your statutes. Because dignity is not a credentialed privilege. They accepted, perhaps because they understood, perhaps because they feared another public reversal. Either way, the changes moved forward. Days later, the younger public defender organized a small rights clinic at a community center. Folding chairs, a borrowed projector, a handful of people who came because they'd learned the hard way that courts did not always translate. She taught them what shall meant, yes, but also what respect should look like, and what to do when it didn't. The woman who had filmed hosted a discussion at a local cafe, inviting neighbors to talk about assumptions, public shaming, and the way laughter could become a weapon without anyone noticing until it cut. And the older man went back to the public building that had started it all, not to prove anything, not to reopen wounds, simply to reclaim peace, to refuse to let a hallway become a haunted place in his mind. The lobby looked the same at first, the same linoleum, the same fluorescent hum, the same desk where people lined up with paperwork and patience. But then he saw the sign. It was rewritten. The font was larger, the language clearer. It asked for cooperation without implying guilt. It explained the policy, but it also explained the process. Staff would answer questions, provide accommodations, and attempt de-escalation before any enforcement action. It used words like please and thank you without sounding performative. It looked like someone had finally considered that citizens were not problems to be managed. The clerk at the desk glanced up. Her expression flickered, recognition, then something like remorse. She straightened. "Good morning," she said, voice normal, not sharp. "How can I help you?" He nodded. "Good morning," he replied, and the exchange landed with the quiet power of what it should have been the first time, ordinary courtesy. He carried the worn leather folder with him, out of habit more than necessity. But this time, it stayed closed. He did not need to brandish proof to deserve respect. He never did. That evening, at home, a grandchild sat across from him at the kitchen table, elbows on the wood, eyes curious. "So you really wrote it?" the child asked, half amazed, half amused, as if discovering a secret superhero identity. He smiled, small and tired. "I helped," he said. "A lot of people helped." "Why didn't you just let it go?" the child asked, echoing what others had said before, the question that always arrived when standing up looked inconvenient. He stirred his tea, watching the swirl settle. "Because when you let it go," he said gently, "it learns it can do it again." The child frowned. "But you could have gotten in trouble." He nodded. "I did get in trouble. For a while." He looked up, eyes soft. "But trouble isn't always the enemy. Sometimes trouble is the price of making a room remember you're human." The child picked at a crumb on the table. "Are laws supposed to be like weapons?" "Laws are tools," he said. "A hammer can build a house, or it can bruise a hand. The tool doesn't choose. The person holding it does." He tapped the closed folder lightly. "And sometimes you have to remind people what the tool was made for." The grandchild glanced toward the living room where the TV murmured, where the world spun its endless clips and takes. "Did everyone online stop being mean?" the child asked. He exhaled a quiet laugh. "People are people," he said. "Some learned. Some doubled down. But a few changed their minds. That's enough to matter." Later, alone, he thought about the courtroom, the heavy air, the impatient judge, the polished attorney, the chuckles that had bounced off the walls like thrown pebbles. He thought about how quickly a room could decide what someone was, based on skin, age, clothes, silence. He thought about how dignity could be mistaken for weakness when people were hungry for spectacle. He also thought about the moment the laughter stopped, the moment the room became still, not because it was scared, but because it was listening. There was power in that kind of silence, a respectful silence, the kind that made space for truth instead of rushing to fill it with assumption. He placed the worn leather folder on a shelf by the door, still closed, as if letting it rest. Outside, the night pressed against the windows, calm and dark. Inside, the house held the soft sounds of ordinary life. And somewhere in the city, in that same courthouse, another case would be called. Another defendant would sit beneath fluorescent lights. Another attorney might try to use certainty like a weapon. The difference now was small but real. A sign rewritten, a protocol clarified, a few people trained to pause before escalating, a few bystanders reminded that watching is not neutral when harm is happening in front of you. Because the truth was simple, even when the system tried to complicate it. Dignity is not something you earn by impressing a room. It is something you carry, and something others are obligated to recognize. So when power tries to shame someone in public, who are you in that room? The person who watches, the person who laughs, or the person who speaks? And if it were your dignity on the line, what would you want the silence to mean?